Are we in? I can't hear you, Joel.
You can't.
I can hear you now.
Okay, that's good.
Welcome to another episode of You Can't Make This Shit Up. David is in the beautiful state of Illinois. I believe that's where you guys house that
Yes.
nice huge city.
Yes.
And I am here at the campus of UCF, University of Central Florida, and excited to be here. Hopefully, we have some topics we can talk about this beautiful campus here in Orlando. And David, I am so excited that you are in Chicago, and tell us what we're going to be talking about today.
Sure. And thank you, everyone, for being a loyal follower of You Can't Make This Shit Up, our flagship podcast for the JN Washington Network. So let's get into it. A landmark Supreme Court case, SEC versus Jarkesy, threatens to dismantle the Securities and Exchange Commission's use of administrative law judges, or as we call them, ALJs, a cornerstone of the agency's enforcement powers. So, the challenge actually is to the administrative state, a term used to describe the vast network of federal agencies and their rule making authority. And this can have so many far reaching consequences, potentially leaving many government employees vulnerable to job losses or reclassification as contractors without union protections or job security. So, we're going to get right into it. My statement on this is that at first I was going to approach this, Joel, in a very typical liberal way. But you know something? With the conservative review, and I'll say that I'll use that word review very loosely, of the functioning of government in our lives is something that the liberals should take take a lesson from. Liberals should also look closely, very closely at some of the actions that they're proposing in legislation, in lawsuits, on the functioning of government. So I understand why this is happening, but my greatest fear is that if we do lessen the role of government and empower the executive branch, and if that executive branch has a president that their interests are not in the best interest of America as a whole, then we've got some issues. Okay, Joel.
Well, David, I really thought this was a very interesting topic, and I'm surprised at where you're going on this, but ALJs are something we don't talk about very often. But again, this kind of goes to uh, they're not elected, they're not appointed by the president. We'll get into the qualifications later. So, but the protections that they are given for termination, there's no. It's very difficult to get rid of them, and some of them actually work cases that aren't even in their legal field because they get overwhelmed. We should have. So I'm going to say that we should have judges that it should be in the judicial system. It shouldn't be a separate. May it slow it down? Possibly, but I think that again, we're a democracy in certain ways, and we should expect that the people that are making these decisions, our decisions, are representative of the people and chosen by the people or the representatives we put in office. So that's where I'm going to go with this.
Right, and I thought this would be a topic that you would particularly be interested in because it does talk about constitutional issues, particularly Article, oh Jesus, 3,
There you go.
the executive branch.
Yes, I'm not going to go. Listen, I'm not going to go on the executive branch because I have had my 2025 frustration. So I don't see this as actually, I would say that it's even possible if the Supreme Court were to make a decision that it doesn't go to the executive branch, as interesting as that could be. But again, we have the judicial committee in the Senate that does make sure that all appointments are vetted. So it's accountability, David. The ALJs they're not elected. They're not elected by the public, and they're not directly subject to the same checks and balances as other government officials. This lack of accountability can lead to arbitrary, unfair decisions, and that's kind of where I'm going with that.
Right, and I believe that is what Jarkesy, the defendant in this matter, is trying to say, that he wasn't provided his due process, the opportunity to have a trial by his peers, a jury of his peers, and therefore this whole administrative law proceeding is unfair. And I think it was, I mean, despite all the sanctions and fees and accusations levied against Jarkesy, uh, he does have a right to a trial per the Constitution. And as I understand the executive branch, Article 3 of the Constitution, the president or the executive branch has the authority to apply these different rules or regulations, if I understand that correctly. Um, Now, also, it talks about, speaking of the executive branch, and I think this is what the big concern is, and this is the other piece that I like to address, is that it's related to the unitary executive theory promoted by the Conservative Federalist Society, and it could have broad implications, meaning that the unitary executive theory argues for concentrated presidential control over the executive branch, potentially allowing the president to fire government employees who don't pledge personal loyalty. Now, that's a caveat. Potentially, that's a caveat there, allowing the president to fire government employees. And if the Supreme Court embraces this theory, it could empower a President Trump or President Biden to replace nonpartisan civil servants with loyalists. That is the concern that I see on the other side of the coin. Are we going to see the remake of our regulatory system? And how would a decision, and the Supreme Court listened to arguments yesterday, November 29th, in regards to this particular case. And there were a lot of questions in regards to the administrative state stipulation in this argument. So that's the fear that I have, is that we're going to see a lot of people reclassified, deunionized, or out of work.
See, there's that union word. So I like the fact that the qualifications for an administrative law judge, it's going to vary. People, we're talking specifically right now about the SEC, right? So we're focused on the SEC, but they're throughout the federal government and agencies. So the qualifications vary from certain different agencies, but they have to have a law degree. They have to be high. They have to have high academic achievements on the bar administration. They have to have legal experience in the field that they're going to be representing, and sometimes they have an examination. But does that really? And that's the minimum. They have to have strong written and oral skills. They're supposed to be fair and impartial. This is where you're getting at, the fair and impartial. ALJs must be able to maintain impartiality and fairness in their decision making. Does this not pertain if the Supreme Court says, okay, you're right, they should be elected or appointed? So that's kind of where I still think that in all our judicial is supposed to be the backbone of the judicial system, that fair and and balanced approach. So I don't see how we could have a loyalty oath for any judge. I mean, just like we shouldn't have a litmus test. But David, you are making a solid point. There are a couple of things that I will disagree with my party on is the cost. Again, are we going to spend more money if we do this? Because right now you're limited. You have so many ALJ positions, right? What happens when it's opened up to the legal system, and then you see how costly those processes are? I believe this has been in effect since Roosevelt. So this has not even been changed for years. I mean, for for a long time. So is this going to be a cost that we're going to have to absorb in the federal government, and have we prepared for that? Smaller government, okay, so yeah, we eliminate the ALJs, right? We eliminate that, but then we go into the legal system, and the legal system's even more expensive. To me, I ponder this, and I hope the judiciary looks at this also and says, you know what, maybe this shouldn't be all in the president's court. But I also see the conservative thing. Why are we having people that have to be terminated for a cause, and have all these extra steps? With the VA has treated me better since we had legislation that loosened the fact that my care providers must give me good care or they could get terminated. That protection is not there as solid as it was before. And my care has improved. Sometimes a little bit too much, where they're asking me, trying to make sure I have every ache and pain taken care of, and I'm not only there for one or two things. So, but again, we were the reason that we have a problem with painkillers. We were the highest prescribers in the VA, but that's because these VA providers were just trying to give us pain relief and get us out of there, and probably not taking that personal touch that we were expecting. So again, a two-sided coin here, David, where I think there's plenty of places where we could compromise. If this was thrown out, I think it needs to be the Congress and the president coming up with a solution.
According to a NPR article by Nina Totenberg late last night, the six conservative judges seem to have zeroed in on the unitary executive theory piece of this legislation, or of this particular uh, court case. We're talking about Article 3 courts, where 2,000 of these ALJs are pretty much on the line. And that's, like you said, that's a lot of judges to replace. And if that's the case, and what, and I see both sides of the coin, I really do. As I look back on our conversations about the independent legislature theory, and the conversations we were having about that, the recent court cases, Jackson versus Dobbs, which sent the decisions by state governments to regulate abortion. We saw the decisions in regards to diversity, equity, and inclusion programs, affirmative action. We are seeing the the conservative movement look very closely at our rules, regulations, and legislative endeavors, and say, "Hey, we need to be very concerned about where our government is going." And sure, the conservatives have joked about making government so small you could drown it in a bathtub. Okay, I get that. But at the same time, we want government to be for the people and by the people and effective for the people.
Mm-hmm.
The SCC versus, excuse me, Jarkesy is going to be a very important decision about the administrative state. I see the challenge. It's taken me a while to wrap my brain around the legal aspect of this. And there are other issues in this particular case that the justices will be looking at. However, judging from the oral arguments yesterday, November 29th, it looks like the conservative wing of the, or the conservative justices um, reviewing this case are pretty much going to be focusing on that particular piece of the law of regulating the ALJs. And this unitary executive theory is going to be fleshed out more.
I would like to see. I didn't have a chance to keep up with what was going on yesterday in the Supreme Court itself. But I'd like to see where Roberts is on this. I mean, conservatives like to beat up on Roberts, but I don't. You know, this is a guy that truly waited to the last minute on Obamacare to talk about,
Yeah.
whether it was a tax or not, and it took him time to make that decision, and he swung that decision. So where will he be on this? Is he really for a powerful, executive branch, or is he going to realize that will weaken the judiciary, that'll weaken the Congress? Congress already gave up all its power. I mean, with executive orders and all this other stuff, how much power do you give to the President of the United States, no matter what party he's in? So I would be looking at Roberts. I'll take today and look a little closer. But yeah, I see both sides on this one. But it's this guy has a really good point. He didn't get a jury trial. He didn't, he could have had, this is like every single time you sign those things at Microsoft and all these programs. Are you really reading them? Are you really getting down to the nitty gritty? Because you're just giving all your legal rights away with adjudication. I mean, you don't even understand how adjudication works. It's not like you get your day in court. So they own you. So I would wrap this up with, I hope that the decision has clear written, that the writing on this is clear, and that where it goes is clear. So I'll be waiting for the decision in the writing, because it'll all be in how it's written, whether it's a pro or a con. Even if it's they side with, I'm not going to say his name right, Jarkesy. Jarkesy. Even if they favor him, I still think that they may have to say, this is why, but don't go here.
Mm-hmm.
So.
And my closing statements here. First of all, you sound so much better. I hear you more than I do the background. So whatever you did, John, it sounds so much better on my end, and I hear Joel much clearer.
Well, you sound fantastic, and I don't know why you wouldn't think you sound good. It sounds good. Your audio is good.
Awesome. To address your point about Chief Justice John Roberts, going back to what I was saying about all six conservative justices questioning the notion that an administrative agency can impose these penalties without offering the option of a jury trial. This is what Chief Justice Roberts said. I quote, "It seems to me that undermines the whole point of the constitutional protection in the first place." Mm-hmm. So it seems like Roberts is saying that allowing ALJs to make decisions without giving the defendant or the person in charge in this particular situation with securities fraud the option to a jury trial does violate the Constitution protections that are afforded to our citizens.
Is this something that they may say that if you use if you use ALJs, that you still have now that you'll have to offer a jury trial. Maybe that's all they have to do. I'm going to say I pray for that, but I don't know if that's capable with the way it's written. But yeah, they need to be impartial. They need to be impartial. They need to really give the defendant the opportunity to have a case. And you know, the whole point of having a jury trial is so you don't have to have a judge make a decision. You can go off of feelings. You can go off of, having to make sure it's 100% proved to, an outside audience.
Yeah.
So
I see your point. And right now, I feel like another cup of coffee. So I'm going to close it out unless you have any other
no,
words of
David,
wisdom.
I honestly, I hope everybody likes, shares. Tell us what you think, because we really want to hear what you think, because our show is about you. And we love judicial candidates. We do a lot for judicial candidates. And does this open up the field for you to have an opportunity to run for a ALJ position or something like that? I mean, just think about it. But don't go in blind. Make sure you got people out there working for you. David does an incredible job with all his judicial candidates. And he's not afraid to go against a sitting judge. So, again, keep an eye out. David has the credentials for this, and Jay in Washington is ready for you. Again, you can't make this shit up. The Supreme Court's going to make a decision, and we're going to see if they give their power away or if they really stick to the Constitution and give this guy his fair day. So, again, like, share, and get out to Chicago where it's freezing cold. I'm sure it's not like down here where it's 71 degrees. It's nice and cool.
Ouch.
But,
Ouch.
yesterday was
Beautiful.
58, so it was kind of, we had that weather that you really like, David. It's just cold
Yes.
enough to put on that turtleneck and be comfortable.
Exactly.
Now you have to put a jacket on to go outside.
Everything bundled up. Oh, Jesus. Yes.
It's great seeing you, David. And again, thank you to our audience. It's wonderful. And UCF, if you're a young person trying to get to college, UCF is a great place to go. We get our interns from here, the majority of our interns from here, because they're quality students, and we want to keep them here in Orlando so we can make Orlando a better place.
All right. Thank you, everyone.